Ready? Set? Let's go. 8th lecture, trademarks. Trademarks are really neat because they happen automatically. You don't have to deal with a lawyer. You don't have to file a registration. They just happen. The only other thing that's sort of like that is trade secrets, which just happen provided you take special care to maintain confidentiality. But copyrights just happen the moment that you fix something in a tangible media. But there you really need to get the registration in order to optimize your claim for damages. But with trademarks, you get the full rights automatically without doing much of anything other than using the trademark. A trademark is a right owned by a single entity to exclude later users in a territory of a non-functional designation, such as a word or a name or a symbol, a device or other designation or combination thereof, that the entity authorizes to represent to the public as either a source or quality standards of goods or services associated with such designation. It's real simple. Whatever you're going to call whatever it is that you're doing, that's your trademark. Now there are related terms, and those are service marks, and that's simply a trademark that's used with services. H&R Block for tax preparation services, or Walmart for retail sales. You can also consider the word trademark to be a more narrow term that only encompasses trademarks used with goods as opposed to service marks that are used with services. But conventionally, trademark as a term is used to encompass both goods and services. Sometimes it's only used to describe the marks with regard to goods per se. And then there's another category of term called trade name. Trade names are used to name a business. And you can have a trade name that does not serve as a service mark or a trademark, but it is simply used to designate the name of a business. There are two other categories of marks that are protectable. One is a collective mark, which is used by a group to signify its members as the source of the members. That trade and professional associations have collective marks. Labor unions, fraternal, religious, and educational organizations have collective marks. And lastly, there's what's referred to as a certification mark. A certification mark is used to certify standards set by a third party, most notably UL for Underwriters Laboratory and the Good Housekeeping Seal of Approval are both certification marks. Basic trademark rights are automatic. In the United States, all you have to do is use the mark and you automatically get rights under what's referred to as common law or under the equivalent statutory state law where states have passed legislation to codify what the common law is. In the United States, acquiring a basic trademark does not require a lawyer or a registration process. And this is the fundamental principle of trademarks. The purpose of trademarks is to prevent a likelihood of confusion on the part of the relevant customers as to the source or quality of the goods or services without unnecessarily limiting competition. So it's this test of likelihood of confusion that is the measure of whether or not people will be violating a trademark by adopting a different mark that is close to the owner's trademark. Generally, a likelihood of confusion may be inferred from proof of actual confusion. An absence of likelihood of confusion may be inferred from the absence of proof of actual confusion if there has been significant use by both parties of the respective designations in the same geographic market for a substantial period of time, and any resulting confusion would ordinarily have been determinable. And if you can't find any, then it's probably not true that there's a likelihood of confusion. There can also be a likelihood of confusion without actual confusion, particularly with a newly announced or newly introduced product or services, where there hasn't been time for the actual confusion to manifest itself. But nonetheless, it's likely that people will be confused because the marks are too close. There can also be no likelihood of confusion where there is actual confusion, particularly where there are customers who may well be confused regardless of the trademark used. We had a lawsuit some time back involving the rights in the trademark Big Mac. And I came to find out that a lot of people order Big Macs in whatever restaurant they go into, regardless of the fact that a Big Mac is a McDonald's brand trademark. And people who order sandwiches in one fast food restaurant oftentimes use the name of a sandwich from another fast food restaurant in placing their order, just as sometimes people ask for Cokes when in fact they know only Pepsi is being served. So some people are confused no matter what. That doesn't necessarily mean that the marks are inherently likely to confuse people. Some people will be confused no matter what. It's not a property of the mark, it's a property of their mind. Categories of terms. Now, there are three ways that we break down trademarks into different categories. The first is that the trademarks are inherently distinctive. That's sort of the best from the trademark perspective. Second, the trademark is one which has acquired distinctiveness through secondary meaning. And third, the term is generic. And we will consider each of those in turn. A designation is inherently distinctive if its nature and the context of its use lead prospective purchasers to think that it serves as a trademark. Some of the clearest examples are Kodak for cameras, Apple for computers, Blue Bunny for ice cream, and Google for search engines. Nobody would think that those are descriptive terms for what it is that the trademark relates to. Distinctiveness. A designation that is not inherently distinctive may become distinctive through its use as a mark. And then the public will generally learn that, in fact, this is a mark, even though when they first saw it, they may not be quite so sure. In such a case, the acquired distinctiveness is said to have acquired secondary meaning. For examples, Steak and Shake, General Electric, and Best Buy. Those would be examples of trademarks that when you might have first seen them, you wouldn't have appreciated that they were trademarks. But after many years of knowing that they are indeed trademarks, you then accept them as being trademarks because they have the secondary meaning that has been acquired over time. Descriptive, geographic, and personal name designations are not inherently distinctive, but they may acquire secondary meaning. Descriptive or suggestive marks would include TurboTax for tax preparing software, Manpower for temporary employment, U-Haul for trailer rental services, Toys R Us for retail toy sales. Geographic would include American Airlines for airline services, Michigan for cottage cheese, Lafayette Bank and Trust for banking and trust services in Lafayette, for example. And personal name, Mrs. Butterworth for pancake syrup, Earl Scheib for auto painting, Mary Kay for cosmetics, Calvin Klein and Liz Claiborne for clothing. Just because somebody's name is used with a product does not inherently make it a trademark, but over time it will acquire secondary meaning and be a protectable trademark. And then the last of the three categories is generic. A designation is generic if it is understood by prospective purchasers to denominate the general category, type, or class of the goods, services, or business with which it is used. A trademark cannot be obtained on a generic designation. And if a trademark becomes generic, it is no longer eligible for trademark protection. Examples of former trademarks that are now generic include aspirin for Bayer AG's brand of acetyl salicylic acid. Escalator used to be the trademark for Otis Elevator Company for its moving stairs. Thermos used to be the trademark for Thermos GmbH's vacuum flasks. All of these things in the list here are examples of trademarks that were once enforceable trademarks that became lost because the public stopped thinking about them in the context of being a trademark and thought about them in the context of describing the actual goods, regardless of who made them. Examples of trademarks that are close to becoming generic but are perhaps not there yet would include Xerox for photocopiers, plexiglass for shatter-resistant polymer glass, Kleenex for facial tissues, and Band-Aid for adhesive bandages. There's certain categories. Yes?
So for the generic things, did they have to expire their trademark protection to become generic, or if people just use them enough?
It just happens by force of the public's changed perception. There's no formal proceeding that goes on that changes them. It's all in what happens in the mind of the relevant consumers. And when the consumers start thinking about those as being generic, then those rights are no longer enforceable. So when they try to enforce those rights in a court of law, the court's going to look at survey evidence showing that, in fact, the public no longer thinks of these things as a trademark, and the courts then won't enforce those trademarks when they try. A trademark cannot comprise immoral, deceptive, or scandalous material or matter that may disparage or falsely suggest a connection with others. For example, bureau model for a firearm may suggest a connection with the Federal Bureau of Investigation. And then the Federal Bureau of Investigation can seek to cancel from the trademark register any registration on bureau model if they think that it's going to mislead people into thinking that the FBI had something to do or endorsed that particular product rather than the private applicant that applied and tried to get that trademark for their own. There are specific prohibitions listed in a particular statute if you wanted to know what the Congress has specifically exempted out from being protectable. Another nice thing about the trademark, which is the same as trade secrets, is that they can last as long as the trademark continues to be used. And trade secrets can last as long as the trade secret continues to be a secret. Unlike copyrights, which have an expiration that's a long way out, but still will expire, and patents generally expire 20 years from filing. Rights in a trademark can be lost by several things. If you expressly abandon your trademark and you announce to the public, we're giving up this trademark, we'll never use it again, you've lost your rights. And you can reestablish them if you wanted, but at least at that moment, they're gone. If you just simply stop using a trademark and you have no intent to restart that use, then you've lost your rights through abandonment, and it's rebuttably presumed that after 3 years, you've given up your right to restart and still claim trademark rights from your earlier use date. You can allow the loss of distinctiveness. of your trademark through third-party infringement without a reasonable effort to end. One thing about a trademark is if you are using your trademark and then somebody else adopts that same trademark, after a while the public won't be able to distinguish whose products they are, and the trademark will cease its function. And therefore the rights will be lost to both parties. So you can really only have one owner of a trademark for a particular goods in a particular geographical area. Otherwise, if you have two people both using the same trademark, it's no longer serving its function of a trademark. It is then unenforceable by either party. So a trademark owner does have a duty to police their mark, and if somebody is infringing in a substantial way, they have a duty to get them to stop, or else both sides lose their trademark rights. Another thing about trademarks, in order for them to have any meaning, they have to represent a particular source of goods or a particular quality of product. And if the person who is trying to own and preserve a trademark fails to exercise control over the quality or the source, those rights can be lost. Now, this is somewhat unique to trademark law. If you want to license somebody under your trademark, that license has to carry with it standards for quality of products made under that mark, and you have the right. You should always have the right to terminate that license in the event those standards are not being met. Otherwise, you can lose the rights to the trademark. As we've seen with the earlier examples, the trademark can become generic, and sometimes there are other equitable or antitrust concerns that can cause a trademark to be lost or become unenforceable. We discussed the requirement of quality control, and the second bullet point here notes that the owner of a mark should usually be the operating company, not a holding company or shareholder. And that is because if you're establishing the standards for products made under the trademark, you have some liability if those standards result in an unsafe product. And so you normally want to get that removed from the principal or the shareholders. You want to leave it in the operating company where you've got the corporate shield to protect you from liabilities beyond what monies have been put in the corporation. If you do grant a trademark license, you want to consider liability insurance coverage that would go with the liability that goes with the quality control standards that have to be associated with the trademark licenses. There's something referred to as a naked transfer of a trademark, because we've discussed that you have to have these quality control standards associated with the trademark. If you try to assign your trademark and you don't transfer with the trademark the associated goodwill and essential related quality standards, that assignment is invalid. You can't separate those two when you assign them. And a lot of people who are not skilled in this area will assign a trademark, just the name, and have no other wording accompanying that assignment, and no other rights get transferred, and that is generally an invalid transfer. And it oftentimes will extinguish the rights in the trademark. Trademarks are different from corporate names, partnership names, fictitious names. I mean, they could be one and the same words, but the concept is different. A corporate name may well exist in the records of the state, the Secretary of State, where you've incorporated. But if that name is not publicly used or used in a manner to lead to confusion, they do not raise trademark issues. So in theory, I could incorporate the Coca-Cola Company of Indiana and never tell anybody, have it appear on the records, and that could be a just fine company that I run. I just can't tell anybody in the public that this is the Coca-Cola Company and use it to promote my products, or there's another company in Atlanta that will come after me. But just simply making that the name of my corporation without any intent to confuse anybody, just for a holding company, purposes, does not raise a trademark issue. Trademark issues only arise when there is a likelihood of confusion. It's not anything inherent in the mark, it's something that's inherent in how the marks are used. Corporate names, partnership names, and fictitious names equally well have a potentially permanent term. Now this is a selection of the mark that you're going to use for your company is really sort of an interesting debate. Trademark lawyers prefer that the mark is valid and easy to enforce. They're worried about the intellectual property rights in the mark as the primary issue. So they favor an arbitrary mark that's wholly unlike anything anybody else uses, a mark that is not in any way suggestive or descriptive of the product. Kodak for film is a great mark from a trademark lawyer's perspective. The risk in this approach is that the mark may not assist in marketing beyond merely being a distinctive identifier. But trademark lawyers like it. They love a trademark like Google that in no way suggests what that service is, except that now we all know what Google is. The marketing people, on the other hand, take quite a different perspective. They tend to want a mark that customers believe is equivalent to the name of the product, so that people will readily remember and ask for the product by name. Slide and lock for a connector that slides and locks a strap in place is a great mark from a marketing person's perspective. The risk in this approach is that the mark may become generic, or at least competitors will be able to describe their products using generic terms, very much like the trademark, and lessen the distinctiveness associated with the mark. So you have a dilemma as to which mark to pick and why you would pick one over the other. Differently spelled marks, which are phonetic equivalents, offer little help to distinguish from one another. We have a different spelling for Xerox. If you want to use that Zeerocs mark on a photocopier, you will be in big trouble, because that is likely to confuse people when they hear it spoken, when they hear it over the phone. How do you know? Is it the Xerox that starts with a Z or the Xerox that starts with an X? Which one is it? I'm confused. So the person that would adopt this Xerox spelled with a Z would be in trouble and would lose their lawsuit if they're using that on photocopiers. Inspiration for selection of ideal names and avoidance of either potentially conflicting names or diluting generic alternatives often comes from doing a trademark search. So a lot of times you just start searching for names and try one after another until you find one that's not previously used on the same goods and services and is quite different than others, and that works pretty well. At a minimum, prior to adopting a trademark, one should consider searching the Patent Office trademark registration records at uspto.gov for potentially conflicting trademarks. Depending on circumstances, such as substantial investment in a national marketing campaign, a more complete search, such as including a web search, may be desirable. Where there is a small investment in locally distributed product, or where there is little cost to change to a different mark if conflict does arise, then it may be better not to conduct a more complete search. If a more thorough search is conducted and potentially conflicting marks are found, then if one proceeds using the mark anyway, the choice of a bad mark, or the choice of that mark, might be considered to have been in bad faith, weakening a later defense against a claim from a prior user. So that's the difficulty. If you search comprehensively and you find something that's pretty close and you go ahead anyway, then you're going to have a greater risk of liability and perhaps paying for attorney fees of your adversary when they come after you. Now, you can do registration of your trademark under state law with the Secretary of State of the state, but that doesn't really change your rights. You'll have a nice certificate when you're finished with the project, and it will say that you have a state registration of your trademark, but your rights will be identical as if you hadn't gone through that process, other than you won't have the certificate. United States registration can add rights to what you would get under state law, whether you go through the state registration process or just use your common law rights. And it's the U.S. registration that we'll focus on more significantly, because there are some real advantages to U.S. federal registration. And sometimes it's a good idea not to get U.S. federal registration as well. But the nice thing about it is that it is a federal recognition that you have the right when compared with other registrations that have previously been registered. You can do that online. It's reasonably simple. You don't have to have a lawyer. You might want a lawyer for this, but it isn't necessary. The effect of the federal registration. Now, there are two ways you can register. And the way you'd like to register, if you can, is to register on what's referred to as the principal register. The principal register is evidence of the exclusive right to use the mark. However, apart from the constructive notice effect of federal registration in territories where the mark has not actually been used, mere registration does not restrict proof of any infringement defenses which would have been present without registration. And what this means is you can get your federal registration, have it issue, and you have it in your hand, and it's got this really nice seal and it looks pretty. If somebody else was using that mark in another area where you're not using it, or even in the area where you're using it, before you filed your application for registration, your registration doesn't take away their rights. Those rights continue. The only thing the registration does is gives you prior rights to subsequent users who adopt later and who adopt in an area, a geographic territory, where you either are or where you imminently intend to move. Now, there's also an option to register on what's called the supplemental register. If for some reason you can't get your registration on the principal register because you haven't yet established secondary meaning for your mark, you can register on the supplemental register. And that provides some limited value, but it is not nearly as powerful as registration on the principal register. Registration on the supplemental register cannot be used to stop importations. Only registration on the principal register can do that. And it primarily serves as notice to others that the applicant considers the mark to be protectable. And what it also does is provide a basis for a later application to register on the principal register after you've had registration on the supplemental register for a sufficient period of time. If you do register on the supplemental register, that's not considered to be an admission that the mark has not acquired distinctiveness. It just means that you don't want to have to go through the proofs of distinctiveness at the time you're registered. Now, there is something called incontestable status for registrations on the principal register. And you can get incontestable status if there have been 5 consecutive years of use after registration, and there are some exceptions, but if you have 5 years of exclusive use of your trademark, while it's been registered on the principal register, you can then file some papers and have the trademark referred to as incontestable. Now, the term incontestable sounds really good if you're the owner, but they have a whole lot of exceptions to incontestability, which simply means that it's not really incontestable. It's just that the number of defenses that you have are limited a little bit more than if it hadn't become incontestable. And I've listed them all here, and I put at the beginning something to benefit you who are studying for the final exam, that you don't have to learn these exceptions. You can just see that these are exceptions that, in fact, would apply. If you fraudulently obtained your registration, it doesn't count that you got the thing declared incontestable. They can undo that. If you abandon your mark, it doesn't matter that it was incontestable, you've abandoned it. Or if the mark has become generic, it can be canceled because of that. If the mark is being used to misrepresent the source of the associated goods or services, it doesn't matter that it was determined to be incontestable. If the alleged infringer is merely using their individual name or a good faith description of their products or services or their geographic origin, then your mark can't be used against them, even though it's incontestable. And, most significantly, if the alleged infringer has, in good faith, continuously used the mark from a time prior to your application for registration, and that alleged infringer is permitted to continue using the mark in those territories in which he was using the mark when you first applied. He's not entitled to grow his territories beyond those for reasonably expected growth. And so he's limited to the territories he had prior to your application, but he can still continue, and your incontestable mark will be of no avail when you're trying to shut him down. Now, there's a special category, a special way of dealing with certain marks that are considered to be famous. This is different than the regular rules of trademark law that we've talked about, where the standard is likelihood of confusion with regard to the goods and services in the particular territories of use. With famous marks, there are further rights that are obtained through the concept of dilution. And dilution is the use of a mark on different goods that wouldn't normally be afforded protection, but because the mark is so famous, the new adopter is prevented from using the mark even on different goods that are quite different. An example might be if I wanted to start selling pencils and put the name Rolls-Royce on the pencil. Rolls-Royce is a famous, distinctive mark. They don't make pencils, so in theory I could put somebody else's trademark on pencils. Nobody would be confused. You wouldn't expect a company that sells aircraft engines to be selling pencils. And so in theory you could do that, but the concept of dilution says, no, you can't for famous marks. Famous marks can stop the use of that famous mark on almost anything if it's really famous. It's sometimes hard to get the courts to acknowledge that your mark is that famous so as to give you the broader coverage. Normally, trademarks only cover the same goods and services, or those that are likely to confuse as the trademark owner's uses. But with dilution, where you have a really famous mark, it works quite differently. One of the real-life examples that I have had in my experiences when I started out, got to work on patents and trademarks for Gatorade brand Thirst Quencher. And we were really concerned that in the adoption of the trademark Gatorade, that it would be lost as a generic term because there was no other product like it at the time. It got a lot of fame and notoriety, and everybody only knew it by its name, Gatorade. And so it was very important for us to make sure that every use of the term Gatorade had associated with it the term Thirst Quencher, which is the generic term. So we would say Gatorade brand Thirst Quencher or Gatorade Thirst Quencher, so that the public would have a generic handle that they could use for the generic term, and then the Gatorade is the brand that was the most powerful and valuable. And so that's how we we work to try to maintain Gatorade as a trademark and not lose it as a generic term. And you'll see that Band-Aid brand plastic strips or something else where you tag on the generic term after the trademark so to train the public in knowing that, in fact, what you're asserting is indeed a trademark and you intend it to be a trademark. Kleenex brand facial tissues or whatever. So that's just a way to help make sure that your trademark doesn't become generic. Now we can consider foreign trademarks. The laws in most other countries are a bit different than in the United States. And generally, the foreign rights are based more on registration and less on use. We have it really nice here in the United States. It's simply the use of the mark automatically establishes your rights. In a lot of foreign countries, you really are supposed to go through the registration process in order to acquire your right to a trademark. And in some foreign countries, the foreign users have to be registered with the state. And so it's a little more tricky if you go international with regard to trademarks than it is simply for the U.S. applications of your trademark, which pretty much happen automatically. Now, in foreign countries, even though you're supposed to get registration, if the mark is known to be famous, they will afford that protection without going through the registration process, but it is a difficult path to go through. There used to be cottage industries in various countries where they would look at the U.S. market, see which trademarks were becoming popular, then they would rush to the local trademark office of the foreign countries and file trademark applications for those marks in the United States, and then with that leverage, negotiate with the U.S. owners when they were ready to go into that country for the sale of the trademark that they had applied for in waiting for the natural growth internationally of the U.S. companies. That's been dialed back a little bit, but it's still a risk that you take if you're about to grow internationally to not timely get foreign registrations. The decision to seek foreign trademark protection is usually driven by market considerations and an economic analysis. An applicant can receive the benefit of a U.S. registration application if the foreign counterpart is filed within 6 months of the U.S. application under treaties. And there's now developing something that is really powerful, and that is something referred to as the Madrid Protocol. The Madrid Protocol can simplify the filing and maintenance of foreign trademarks in up to 88 countries, including the United States, that are members of the Madrid Protocol. So you can file one application, and it works particularly well if you've got a U.S. registration already in force and you want international coverage of the same scope for the same mark. You can use that as a basis for filing a Madrid Protocol application and have one filing to get 87 more countries. And then the maintenance and renewal of the trademark can be done with one transaction rather than 87 transactions for all of the other countries. And that's being used more and more of late. It's a reasonably recent development in trademark law. Any other questions? No questions. Life's good. Anybody want to go home?